Hi, and welcome back to the Mud Puddle Theory. I am Jerry and Quick, and I wrote the Mud Puddle Theory with a goal to unite and bring us closer together as a nation with the truth concerning our dark past history. Before we can unite and come together as a nation, we must first know and understand the underlying causes for our division, something which I teach not only in the Mud Puddle Theory, but also in my videos. In my last video, the Civil Rights Act of 1964, I stated that while there were some positive things that did come out of the Civil Rights Act of 1964, it not only further divided us as a nation, it also infringed upon the inalienable rights that were given to all of us under the United States Constitution and could not be infringed upon or taken away by government. Even though affirmative action was originally proposed in 1941, President John F. Kennedy, prior to the passage of the Civil Rights Act of 1964, signed Executive Order number 10925, which basically provided that any contractors doing business with the United States government on contracts that exceeded $10,000 had to hire minority contractors to do a lot of the work and had to file a yearly report with the U.S. Department of Labor's Office of Federal Contract Compliance Programs to show that they were in compliance with the executive order. After President Kennedy was assassinated in the passage of the Civil Rights Act of 1964, President Johnson signed Executive Order number 11246, which created affirmative action, which I focus on in this video, and the affirmative action that I'm sure most of you may be familiar with. Affirmative action has been the most controversial of all the laws concerning civil rights, which has not only divided us further and further apart as a nation, but has only began or been detrimental to the oppressed and deprived people that it sought to help. After signing the order creating affirmative action, President Johnson stated that blacks would be voting for Democrats for the next 200 years, which up until this point has been true. This makes me question whether the creation of affirmative action was focused on actually helping the blacks, or was it to get the blacks' vote, which has been considered as a swing vote in most elections. In my video on the Civil Rights Act of 1964, even though Title IV did address segregation of public schools, my main focus was on Title VII under the Act, which dealt with discrimination in employment. In Executive Order number 11246, signed by President Johnson, it not only expanded Title VII concerning discrimination in employment, but it also expanded Title IV concerning public education, which was a major step in providing opportunities and advantages to some simply based on the color of their skin, while denying to others those same rights and privileges as is not only guaranteed under the United States Constitution, but also under the 14th Amendment to the United States Constitution and under the Civil Rights Act of 1964. In the Mud Puddle Theory and some of my prior videos, I stated that because of my past historical studies, I'd already noticed that the truth concerning our dark past history was being misrepresented, mischaracterized, not fully disclosed, omitted, and even was false. Since I do have the knowledge and understanding of the underlying causes for our division, my biggest fear has been that eventually the true facts concerning our dark past history would disappear and will no longer be available, so that we can learn and understand who, how, and why we are being divided as a nation. While the executive order itself that was signed by President Johnson may still be available, the only information that I could find in researching affirmative action was various articles that did discuss affirmative action. However, those articles didn't focus any attention on the part of the executive order that I will focus most of my attention on in this video. Executive Order number 11246, by its wording, clearly discriminated against whites, especially against white males. In essence, the executive order signed by President Johnson creating affirmative action stated that an equally qualified minority would be given precedence over a white male concerning employment. However, in reality, that is not the way it was applied, because most employers who would fall under Title VII when hiring employees were very concerned about complying with affirmative action and avoiding EEOC complaints being filed against them. So, in most cases, they would hire blacks over whites. In the mudpuddle theory, I tell about a client who did fall under Title VII, who wanted to have a consultation with me to discuss Title VII, because he was in the process of hiring an employee, and he had applications from 5 different applicants to consider, 2 of which were blacks. Well, I did explain to him that affirmative action used the term equally qualified. I also emphasized to him that even though the most qualified person he wanted to hire was a white man, it would not guarantee him that an EEOC complaint would not be filed by one or both of the black men that he didn't hire. In order to try to avoid any complaints being filed against him, he ended up hiring a white man who was most qualified, and even though he only wanted to hire 1 employee, he also hired the most qualified of the black applicants. Initially, there were a flood of reverse discrimination lawsuits filed by whites claiming that they had not only been discriminated against concerning hiring practices, but also concerning employment promotions, where less qualified blacks and other minorities were being promoted over them, even though they were more qualified. Some of the reverse discrimination lawsuits even argued that affirmative action was unconstitutional because it not only violated the U.S. Constitution, but it also violated the 14th Amendment to the U.S. Constitution, and even violated the Civil Rights Act of 1964 itself. And I agree. While there were reverse discrimination lawsuits that did reach the U.S. Supreme Court that presented the question of reverse discrimination and the constitutionality of affirmative action, based on my research, the U.S. Supreme Court has never directly addressed either of those issues. In the mudpuddle theory, I do document several of U.S. Supreme Court cases where reverse discrimination and the constitutionality of affirmative action were issues, and the U.S. Supreme Court only avoided those issues. There were cases where the U.S. Supreme Court required the employer to provide training to the minority so that the minority would be qualified for promotion over a white who was qualified, and so forth. Eventually, the number of reverse discrimination lawsuits being filed mainly by white males stopped, because filing a lawsuit by a white male was basically an exercise in futility. It didn't do any good. Perhaps the biggest failure of affirmative action concerns education. Under Title VII of the Civil Rights Act of 1964, the Act simply stated that a person could not be discriminated against based on race, color, religion, or national origin. Affirmative action went much, much further in the requirements for public colleges and universities to admit mainly blacks and essentially reduce standards. This focus of public colleges this force of public colleges and universities to admit some blacks who could not meet their high standards for admission, which only proved to be detrimental to those blacks and only led to their failure. Justice Clarence Thomas, the only current white justice on the U.S. Supreme Court, has expressed his concern that affirmative action is only detrimental to some blacks because it has put them in a position where they can't succeed. If you know anything about Justice Thomas, you know that he was born just outside Savannah, Georgia, where he grew up very, very poor. Through hard work, dedication, and many, many sacrifices that he had to make, he was able to get a good quality education in one of the most prestigious schools, Harvard, where he finished at the top of his class. While his appointment to the U.S. Supreme Court may have been partially based on the color of his skin, he was very qualified and deserving of that appointment. In order to comply with the mandates of affirmative action and the diversity requirements of the U.S. Supreme Court, public colleges and universities began to establish race-conscious policies so that more blacks and Hispanics could meet their requirements. The results were that some of the blacks and Hispanics who admitted could not compete and keep up with the other students, so they usually made much lower grades, were at the bottom of their class, and were far more likely to drop out. On the other hand, if those same students did attend other good schools where they could be competitive and keep up with the other students, they were more likely to be successful. Even though I am talking and making references to blacks and Hispanics, if some whites were given the same preferences who were not qualified and who could not compete and keep up with the other students, I'm sure that the results would probably be the same. It is really not about race, but it's more about intelligence and preparedness. Blacks are being placed in an environment where they cannot succeed. After affirmative action concerning education had been in operation for a while, there were states that began to establish their own guidelines to promote diversity because affirmative action was failing and causing problems in their public colleges and universities. The law that got my attention the most was Proposition 209, which was passed by California in 1998, mainly because California has always been considered to be a liberal state and affirmative action was considered to be a liberal policy. Essentially, under Proposition 209, the public colleges and universities went back to their former admission policies. The blacks and Hispanics who could meet those requirements and were admitted were able to compete and keep up and were very successful. Of course, as is usually the case, a complaint was filed in court and Proposition 209 was set aside. Recently, the Asians, who are considered to be a minority group, filed a lawsuit against Harvard University, arguing that Harvard's admission policy discriminated against Asians who had met the requirements for admission because of Harvard's race-conscious policies that favored blacks and Hispanics over Asians and whites. As part of the argument, they argued that having race-conscious admission policies creates only racial injustice, which is true. They also argued that affirmative action undermines the American values of hard work and determination. Again, the constitutionality of affirmative action will be challenged. It will be interesting to see what the U.S. Supreme Court will rule and whether or not they will again avoid the question. Of course, should the U.S. Supreme Court rule that affirmative action is reverse discrimination and or unconstitutional, this would open the door for whites to have the same rights and privileges that are guaranteed to everyone under the Constitution. In the multiple theory, I mentioned a young man by the name of Jason L. Riley, who is a black journalist for the Wall Street Journal. Jason L. Riley wrote a book titled Stop Helping Us, where he not only discussed the detrimental effect that affirmative action is having on the blacks, but how the government handouts to blacks is making the blacks more dependent on government. Essentially, they were destroying the blacks' drive, motivation, and dedication to succeed. Recently, I read an article written by Jason L. Riley dated December the 11th, 2018, titled, Racial Problems Aren't Only an American Problem. In the article, he stated that, quote, discriminatory programs tend to benefit the well-off instead of the poor, end quote. Statistics show that the blacks who are benefiting from affirmative action are usually the middle and upper middle class blacks and not the poor blacks that affirmative action was intended to benefit. In 2015, when I was doing my research in preparation to write the multiple theory, I learned that the government had made $330 million in scholarships available to blacks for educational purposes while not providing any scholarships to whites. Again, it has been shown that the blacks who actually benefited from those scholarships were middle and upper middle class blacks. Statistics have also shown that blacks are more likely to attend college than whites who are from similar backgrounds. Of course, this is understandable because of the scholarships and other financial assistance programs that were available to the blacks that were not available to whites. Unless whites were able to get academic scholarships, athletic scholarships, or other type of financial assistance like that, the only financial programs available to the whites would be through student loans, which they had to repay after getting their degree. Affirmative action was to provide a good quality education to blacks so that they can earn a better income and reduce the poverty level in the black community and to prepare them for middle class professions. According to Jason L. Riley, quote, black income doubled in the 60s before affirmative action, and blacks were entering middle class professions at a much faster clip in the decades preceding affirmative action than they did in the decades following affirmative action. End quote. Apparently, affirmative action and the other programs provided to the blacks have only made them more dependent and has deprived them of the motivation and dedication to succeed. As stated previously, affirmative action and the other governmental policies created for the benefit of the blacks only undermines the American principle of hard work, dedication, motivation, and making the sacrifices that one needs to make to be successful. If I had made myself clear in the mudpole theory and in my videos, I want to make it very clear that I am in favor and I do advocate true racial equality and a race-neutral government as is guaranteed in the U.S. Constitution, the 14th Amendment, and the Civil Rights Act of 1964. Affirmative action is a prime example of how the people we elect to run our government while trying to please a minority and get votes to stay in power are only dividing us further and further apart and may eventually cause us to follow in the path of the Roman Empire. Thanks so much for watching this video. I hope that you have enjoyed it and that you have learned something that will help you better understand the underlying causes for our division. Please like and subscribe and feel free to share this video on social media with your family, friends, colleagues, or whoever you want to share it with. As usual, I not only welcome your comments, but I encourage you to leave your comments so that we can have the conversations, discussions, and our dialogues that we so desperately need that will bring us closer together as a nation. Please be respectful of others concerning your comments. Please, no cursing, profanity, or name calling. Again, thanks for watching. God bless America.